Good morning, everyone. I'm excited to welcome you to today's presentation. Today, we'll be exploring the relationship between copyright and other forms of intellectual property rights, especially patents and trademarks. The title of our session is Examining the Relationship Between Copyright and Other Forms of IPRs, particularly patents and trademarks. Over the next few minutes, we'll look at how these rights intersect, differ, and complement each other in the world of intellectual property. Let's get started. Let's explore how intellectual property rights, or IPRs, are essential for protecting creative and innovative works in today's economies. These rights help creators and inventors safeguard their efforts and investments. You'll notice that copyright, patents, and trademarks each serve different but complementary roles. Copyright primarily protects creative expressions like music, films, and literature, ensuring creators can control and benefit from their work. Patents, on the other hand, are focused on technical inventions, new inventions or processes that need protection to encourage innovation. Trademarks, meanwhile, are all about brand identity, logos, symbols, or names that distinguish products and build customer trust. Now, with technological convergence increasing, meaning different forms of technology blending together, the lines between these protections are starting to blur. For example, software can sometimes be protected by both copyright and patents, raising interesting questions about the scope of each protection, their limits, and how dual protection might work. This overlapping creates complexities, especially when it comes to software or logos, where questions of scope and dual protection often come into play. Understanding these distinctions and overlaps is key as we navigate the evolving landscape of intellectual property rights in a digital world. Both copyright and patents share the goal of encouraging innovation by giving creators and inventors exclusive rights to their work. Copyright primarily protects expression. Think of things like code, artwork, or literature, while patents focus on protecting ideas or functional inventions, like new processes or devices. In the digital world, especially with software, we see a lot of overlap. For example, the code itself is protected by copyright, but the underlying process or method can be protected by a patent. This dual protection can sometimes be a bit complex, but offers a way to safeguard different aspects of technological innovations. Legal cases like Apple versus Franklin or Diamond versus Deere have recognized that software-related works can be protected through both copyright and patents. This dual protection is important because it helps cover different facets of the same innovation. However, this overlap also introduces risks, such as potential double monopolies, where a single entity might hold too much control over a particular technology. That's why finding a careful legal balance is crucial to promote innovation without stifling competition. So, when we look at the convergence of copyright and patents, especially in software and digital tech, it highlights the importance of understanding both rights and how they can work together, and sometimes conflict, to shape the innovation landscape. Let's take a moment to understand the key differences between copyright and patents. Copyright protects original expression, meaning it covers creative works like writings, music, and art. Patents, on the other hand, are about protecting inventions that are new, useful, and involve an inventive step. In terms of duration, copyright lasts for the life of the author plus 60 years, while patents typically last for 20 years from the date of registration. Another important point is that copyright includes moral rights, which protect the personal and reputational interests of the creator. Patents, however, only confer economic rights, allowing the patent holder to profit from the invention. Getting a patent requires registration. It's not automatic, whereas copyright protection arises automatically the moment the work is created and fixed in a tangible form. Additionally, in Indian law, there's a specific exclusion. Computer programs per se are not patentable under Section 3(k) of the Patents Act. This highlights how different legal frameworks can shape what can be protected and how. Understanding these differences is crucial because it helps us know what kind of protection applies to different types of creations and inventions, aligning with our overall focus on intellectual property rights. Let's talk about creative elements like logos, characters, and designs. These can actually be protected by both copyright and trademark law. For example, think of Mickey Mouse. He's protected as an artistic work under copyright, but he's also a brand symbol protected as a trademark. Copyright is there to protect the creativity behind the design, the artistic expression, while trademarks serve to protect consumer recognition and the reputation of a brand. Courts recognize that some elements can have dual protection. A good example is the Batmobile in the DC Comics v. Toll case, where it was acknowledged that it could be protected both as a creative work and as a trademark. However, there's a risk involved here. Trademark renewal can sometimes extend control over an element even after the copyright has expired. This means that, in some cases, a brand symbol might keep control over a design that should have entered the public domain, which can limit public access and use. So, when dealing with creative elements, it's crucial to understand where the overlaps and conflicts might occur between copyright and trademark protections, and how they can impact each other over time. As we look at the emerging overlaps and conclude our discussion, it's important to recognize how digital technology, AI, and global trade are actually intensifying the connections among different types of intellectual property rights. These advances are blurring traditional boundaries, making it more complex, but also more exciting to navigate the IP landscape. AI-generated works, in particular, challenge our conventional ideas of authorship and ownership. For example, when an AI creates a piece of art or a piece of music, it raises questions about who truly owns the rights: the creator of the AI, the user, or perhaps even the AI itself. This is pushing us to rethink some of our foundational concepts. Turning to industrial designs, these often fall under multiple protections, like copyright and design laws, such as those outlined in the Copyright Act Section 15. This overlapping protection can be beneficial, but it also requires careful legal frameworks to ensure clarity and fair use. The TRIPS agreement plays a crucial role here by harmonizing IPR standards across countries, creating a more predictable global environment. However, because each nation interprets and enforces these standards differently, there are variations that can complicate international trade and innovation. So, what's the takeaway? We need balanced legal reforms that prevent the creation of overly monopolistic rights, which can stifle competition and innovation. At the same time, our laws should protect creativity and encourage innovation, but also ensure public access. Striking this balance is key to fostering a healthy, dynamic IP ecosystem that benefits everyone. In conclusion, as these overlaps continue to grow, understanding and adapting our legal frameworks is essential for supporting the ongoing evolution of technology, trade, and intellectual property rights.